Hello dear aspirants, welcome to Epitome IAS. So dear students, I hope you are doing well and your preparation is in the right direction. So tell me in the comment section whether which attempt you are giving, first attempt, second attempt, or how many years you have been preparing, and tell me whether you are going to give 2025 attempt or 2026 attempt, just for understanding those who are regularly watching these videos. Try and tell in the comment section so that it will be helping me understand which type of students are watching the video. Okay, and we'll be doing the classes in that perspective. So today's class would be the PYQ analysis from the Indian Polity, and it is part 5 of the Union and the State Legislature. So let us start with today's class. So if you see here, the first question is, which of the following statements about the Ethics Committee in the Lok Sabha are correct? Statement 1, initially it was an ad hoc committee. Statement 2, only a member of Lok Sabha can make a complaint relating to unethical conduct of a member of Lok Sabha. Statement 3, this committee cannot take up any matter which is sub judice. So if you see here, they are talking about the ethics committee of the Lok Sabha, and the statement 1 says this ethics committee was initially an ad hoc committee. So these ad hoc committees are temporary committees. They are set up in resolving for any particular issue. Okay, so on temporary basis these ad hoc committees are set up. Okay, so initially this ethics committee was set up as an ad hoc committee, but later on it was converted into a standing committee, permanent standing committee. Okay, so yes, this statement is correct. Initially the ethics committee was an ad hoc committee. Then only a member of Lok Sabha can make a complaint relating to unethical conduct of a member of Lok Sabha. So if you see here, in the ethics committee, usually some people go and make complaint over the conduct of the members of Lok Sabha. Okay, that is the main function of this ethics committee, to inquire into those complaints. Okay, so in this case, not necessarily only the member of Lok Sabha should make the complaint. Thing is, any person. So any person can make a complaint against the members of Lok Sabha. Not necessarily the member of Lok Sabha can make the complaint. So they are saying only the member of Lok Sabha can make a complaint over the member of Lok Sabha. So this is wrong. Any person can make a complaint, but in case any person is making a complaint, he or she needs an affidavit from the members of Lok Sabha, any member of Lok Sabha. And let's say in case a member of Lok Sabha, he is making the complaint, then there is no need for that affidavit. Okay, so this is there. So this statement is wrong statement. Third statement is, this committee cannot take up any matter which is sub judice. So first of all, you need to understand what this term sub judice means. Sub judice means under trial or under judiciary. So let us say there are some cases, there are some things which are under trial, which is under the Supreme Court or High Court or any court. Okay, in that case, the ethics committee, they cannot take up those matters which are there in the jurisdiction of Supreme Court. Let's say there is a matter. Okay, this particular matter is already considered by the courts. It is under trial and the judiciary is about to make a judgment. Okay, it is under trial. In that case, the ethics committee cannot take up those particular cases, those particular matters. Okay, apart from this, matters which are sub judice in nature, also those matters which are published in the media. Okay, those matters which are just published in the media, those things also this particular committee cannot take up. Okay, so if you see here, this statement is a correct statement. So what would be the correct answer? Option 1 and 3, option C is the correct answer. Then if you see here, the late speaker GMC Balayogi constituted an ad hoc ethics committee in 2000. So in 2000 what happened? This particular person, he constituted a ethics committee, and it was a temporary committee. It was not an permanent committee. So it was set up as a ad hoc committee. Ad hoc committee means it is temporary. So then what happened in 2015? Later, this particular ethics committee, it became a permanent committee. Okay. Then any person can complain against the member through another Lok Sabha MP along with evidence. Okay. So any person can complain against the Lok Sabha MP, member of Lok Sabha. But when any person is complaining against the member of Lok Sabha, they need a support from one MP from the Lok Sabha, another MP from Lok Sabha. But let us say the complaint itself is made by a member of Lok Sabha, then there is no need for the affidavit. Okay. And this particular complaint can be raised along with the evidence. They should also produce some evidence, then they can raise the complaint. If a member himself complains, a member of Lok Sabha is going to complaint against another member of Lok Sabha, then this affidavit is not needed. The speaker can refer to the committee any complaints against an MP. So any member of parliament, any member of Lok Sabha, this particular complaint, it can be issued by the speaker. Okay. Then the committee does not entertain complaints based only on media reports. Let's say there are certain complaints. Okay. One member of Lok Sabha is trying to make a complaint on another member of Lok Sabha, but this particular complaint is only based on a media report. Okay. A media published something about a member of Lok Sabha, then this member of Lok Sabha, the first member of Lok Sabha, is making complaint based on this media report, only the media report, then it is not taken up by the ethics committee. Okay, this is there. They should need a actual evidence to take up this particular matter. Okay, then there is another case, that is those matters which are of sub judice. What is sub judice? Those matters which are directly under the judiciary, which is under trial. These matters cannot be taken up by the ethics committee. Okay, so this is what is there. Then second question, as per Article 368 of the Constitution of India, the Parliament may amend any provision by way of addition, variation and repeal. So if you see here Article 368, it talks about the amendment procedure of the Constitution. And this article also mentions these three types of amendments. So by addition, by adding some new provision, or by variation, or by repealing some provision which is already there in the Constitution, by all the three means, the Parliament has the power to amend the Constitution. Okay, this is what is mentioned in the Article 368 of the Constitution. So if you see here, option D, 1, 2, 3, all are the correct answer. So if you see here, as per Article 368, under Part 20 of the Constitution, notwithstanding anything in this Constitution, Parliament may, in exercise of its constituent powers, amend by way of addition, variation, repeal or repeal any provision of this Constitution in accordance with the procedure laid down in this article. So this is directly been taken from the Constitution of India. Okay, from the Constitution of India, the Article 368 directly says this thing, and all these three type of amendment, addition, variation and repeal. Repeal means to remove certain provision. These all three type of variation is, all three type of amendments, is mentioned in the Constitution itself. Okay, next question. Which of the following statements are correct in respect of the money bill in Parliament? Statement 1, Article 109 mentions special procedure in respect of money bills. Statement 2. A money bill shall not be introduced in the Council of States. Statement 3. Rajya Sabha can either approve the bill or suggest changes but cannot reject it. And statement 4. Amendments to the money bill suggested by the Rajya Sabha have to be accepted by the Lok Sabha. So if you see here, they are talking about the money bill. And in the last few classes, we are actually talking a lot about the money bill. There are some special provisions, special powers given to the Lok Sabha in case of the money bill. Okay. So if you see, the first statement says the Article 109 mentions special procedure in respect of money bills. Yes, this is true. Article 109 is actually talking about the money bill. This particular statement is a correct statement. Then, a money bill shall not be introduced in the Council of States. First, tell me what is Council of States? Council of State is nothing but the Rajya Sabha. Okay, so they are saying in the second statement that the money bill cannot be introduced in the Rajya Sabha. Is that true? Yes, we always read this, right? The money bill can only be introduced in the Lok Sabha and it cannot be introduced in the Rajya Sabha. So this statement is a correct statement. Then the third statement says the Rajya Sabha can either approve or suggest changes but cannot reject it. So this thing also we read a lot. In last few videos we used to see this things. Okay, what they are saying is in case of a money bill, the Rajya Sabha cannot reject a bill. It can either propose changes or it can either approve the bill. Is that true? In case of a money bill, the Rajya Sabha has a very limited power. We know that. Okay. So when the money bill is already passed by the Lok Sabha and it is transmitted to the Rajya Sabha only has two options. What are they? Either to approve those that money bill, either to approve, accept, and the second option is to recommend some changes. It can only make recommendations. Okay, but the Rajya Sabha does not have the power to amend the particular money bill or it does not have the power to reject the money bill. Okay, do you understand? So the Rajya Sabha cannot actually reject the money bill and it can only approve or it can suggest some changes. So this statement is a correct statement. Then if you see statement 4, amendments to the money bill suggested by Rajya Sabha have to be accepted by the Lok Sabha. Is that so? So if you see here, the Rajya Sabha can only make recommendation and it is up to the Lok Sabha whether to accept these recommendation or whether to not accept these recommendation. It's up to the Lok Sabha. The changes suggested by the Rajya Sabha is not binding on the Lok Sabha. Okay, the Lok Sabha has a upper hand. It can either accept the changes or it can either reject the changes proposed by the Rajya Sabha. Okay, wow. So this particular statement is saying amendments to the money bill suggested by the Rajya Sabha have to be accepted by the Lok Sabha. No, it is not obligatory on the Lok Sabha to accept the changes, to accept the recommendations. Okay, so this particular statement is a wrong statement. So what would be the correct answer? The correct answer would be 1, 2, 3. Option C is the correct answer. So if you see here, Article 109 of the Indian Constitution mentions the special provision with respect to the money bills. Okay, then as per Article 109(1), a money bill shall not be introduced in the Council of State. So this particular article says that a money bill can only be introduced in the Lok Sabha, not in the Rajya Sabha. And this also says that a money bill has been passed by the Lok Sabha, it shall be transmitted to the Rajya Sabha for its recommendations. And the Rajya Sabha shall, within a period of 14 days from the date of receipt, okay, whatever. These are directly mentioned, this provision from the Constitution. Okay, directly they have given the terms or the proper procedure mentioned in the Constitution of India regarding Article 109. Okay, in the next slide we'll be seeing it in a very simpler format. Okay, this is like almost in one statement they have given all these details. So it may be confusing for you. In the next slide, we'll properly try to understand each and every term. Okay, every procedure. So what this says, as per Article 109, Lok Sabha may same. Okay, next slide I'll try to explain this. So first point is, in case of a money bill, you should remember, first point is the money bills can only be introduced in the Lok Sabha and it cannot be introduced in Rajya Sabha. This is the first point you have to remember. Then the second point which you have to remember is the money bill can only be introduced in the Lok Sabha with prior permission from the President or prior recommendation from the President. So without the prior recommendation or the permission from the President, they cannot introduce a money bill in the Lok Sabha. Okay, so first point, only it can be introduced in Lok Sabha. Second, only after getting the permission from the President, they can introduce the bill, money bill, in the Lok Sabha. Then money bills are considered to be government bills. Okay, these money bills are actually considered to be government bills. That's why it's obligatory that money bills are presented by or introduced by a minister. Okay, we know that we have members of parliament in both Lok Sabha and Rajya Sabha. Okay, so there are some ministers, we say the council of ministers, and there are some other members who are not the ministers. Okay, so these members are called as private members. Okay, so apart from the ministers, we have a private member. So these private members are also the members of the parliament, but who are not the ministers, who does not belong to the council of ministers. These are the private member. So they are technically saying that the government bill, the money bill, it is a kind of government bill. It belongs to the government, right? So these money bills can only be introduced by a minister. It cannot be introduced by a private member. No, a private member cannot introduce a money bill. Okay, then after the money bill is passed by the Lok Sabha, it is transmitted to the Rajya Sabha, and the Rajya Sabha has only two options, either to accept it or to make recommendation, and it is up to the Lok Sabha whether to accept this recommendation or not. It is free. Okay, it is up to the Lok Sabha. It is not obligatory on the Lok Sabha to accept the recommendations made by the Rajya Sabha. Okay, yeah, that's what is given here. Then the Rajya Sabha must return the bill to Lok Sabha within 14 days. This is important. So within 14 days, once the bill is transmitted from Lok Sabha to the Rajya Sabha, within 14 days the Rajya Sabha must respond. It can either approve the bill or it can make some recommendation and tell the Lok Sabha, or let us say the Rajya Sabha is not responding to this money bill. Then what will happen? In 14 days, with the expiry of this 14 days, this bill will automatically be considered as passed in Rajya Sabha. Okay, already this bill was passed in Lok Sabha and now it is considered that it is passed in Rajya Sabha. So technically, with the expiry of the 14 days time period, this bill, this money bill is considered to be passed in both the houses. Okay, then if Lok Sabha accepts any recommendations made by the Rajya Sabha, let's say the Rajya Sabha made some recommendation and the Lok Sabha accepted those recommendation, then what will happen? This modified form of the bill will be considered to be passed in both the houses. And there is another case when the Lok Sabha does not accept these recommendations made by the Rajya Sabha. Then what will happen? Then the original form of the bill, not the modified form, the original form of the bill which was sent by the Lok Sabha will be considered to be passed in both the houses. Okay. Then if Rajya Sabha does not return the bill to the Lok Sabha within 14 days, then what will happen? Then it is considered that the bill is passed by Rajya Sabha. If the Rajya Sabha is not at all responding, it is not approving, it's not making any recommendation, it's doing nothing, then within 14 days, like after the 14 days, then this bill, money bill, will be considered to be passed in the Rajya Sabha. It was already passed in Lok Sabha. Now it will be considered to be passed in the Rajya Sabha also. Okay, then it will go to the president, for his consideration. Now the president has, two options. One, to give assent to this particular money bill, or to reject this particular money bill. But he cannot send it for reconsideration. Okay, whenever, if you see, in case of an ordinary bill, the president has some options. One is to give assent to this particular bill, or to send it for reconsideration, and the other option is to withhold the assent. Okay, these are the three options. Now, when the money bill is presented to the president for his assent, he only has two options. One, to either give assent, or to either withhold his assent. But he cannot send it for reconsideration. Okay, and most of the cases, if you see, the president would be giving his assent. Why? Because this particular money bill is actually introduced in the Lok Sabha with prior permission from the president. Okay, with the prior permission of the president only, they can introduce this money bill. So with his permission only, they introduce the money bill in Lok Sabha. So in most of the cases, what he will do? He will give the assent to the money bill. Okay, then, so this is what is given here. You can have a look at it. Okay, next question, with reference to union budget. So first of all, I want to tell you that whatever questions we are seeing today, okay, every question we have around 7 questions. So these 7 questions are from the 2024 paper. Okay, from the 2024 prelims, we have taken these 7 questions, which are directly from the topic union and the state legislature. Okay, so that's why we have not mentioned the year here. All these questions in today's video, it belong to the 2024 paper, 2024 prelims paper. Okay, so with that, we'll continue with this question. With reference to the union budget, consider the following statements. So statement 1, the Union Finance Minister on behalf of the Prime Minister lays the annual financial statement before both the houses of Parliament. Statement 2, at union level, no demand for grants can be made except on the recommendation of the President of India. So in this question, they are talking about the union budget. Okay, and the first statement says that Union Finance Minister on behalf of the Prime Minister, he lays the annual financial statement before both the houses of Parliament. Yes, it is true that the Union Finance Minister will be presenting the budget, okay, in both the houses of Parliament. Budget is nothing but the annual financial statement. Okay, the another term for budget is annual financial statement, and only the annual financial statement, this term is mentioned in the Constitution, and the term budget is not directly mentioned in the Constitution of India. It is only for our understanding we are using the term budget. Okay, so if you see here, yes, it is presented by the finance minister, no doubt about it. But what they are saying is, on behalf of the Prime Minister, he or she will be presenting the budget. So the thing is, no, not on behalf of the Prime Minister. It is on behalf of the President. So if you see here, the Union Finance Minister will be presenting the budget to both the houses of the Parliament on behalf of the President of India, not on behalf of the Prime Minister of India. So we can eliminate this option. We can eliminate this statement. Then statement 2, at union level, no demand for grant can be made except on the recommendation of the President of India. So this is directly given in the Constitution of India, this statement. In union level, any demand for grant can only be made by the recommendation of the President of India. Okay, so this statement is a correct statement. So the answer would be only 2. Option B is the correct answer. So if you see here, Article 112 of the Constitution. Article 112 of the Constitution says that the President of India shall, in respect of every financial year, cause to be laid. Who is the cause to be laid? That is the President of India, not the Prime Minister of India. Okay? Cause to be laid before the Houses of Parliament an annual financial statement. So directly in the Constitution, they are mentioning this term annual financial statement and not the term budget. Okay, this is also you should remember. And if you see here, Article 112 directly says that the cause to be laid is the President of India. So on behalf of the President of India, the Union Finance Minister will be presenting the budget in both the houses of the Parliament. Okay, then so the Finance Minister lays the budget in the Parliament on behalf of the President. Then there is another article, that is Article 113 of the Indian Constitution. It says that no demand for grant shall be made except on the recommendation of the President of India. So whenever there is a demand for grant to be made, it can only be made with the recommendation of the President of India, and this is directly mentioned in Article 113 of the Indian Constitution. Okay, then next question. With reference to the Speaker of the Lok Sabha, consider the following statements. While any resolution for removal of the Speaker of Lok Sabha is in consideration, he shall not preside the Lok Sabha. Then statement 2, he or she shall not have right to speak. Statement 3, he or she shall not be entitled to vote on the resolution in the first instance. Okay, what they are saying is whenever the post of speaker, okay, whenever there is a removal resolution for the speaker is in consideration in the Lok Sabha, then the speaker has some options what he can do and what he cannot do. Okay, first statement says he or she shall not preside. Yes, when there is a removal resolution is in consideration, okay, of the speaker, so technically he can't preside that meeting, right? If he is presiding, then obviously it is against him, so he can't preside the meeting. So this is correct. He or she shall not preside the particular meeting, okay, when his removal resolution is in progress. Then second statement says he or she shall not have right to speak. So if you see the speaker, when his removal resolution is in the progress, then he has some rights. He can be present in the meeting. Okay, no one can stop him from being present in the meeting. Then he has the right to speak. Okay, he has the right to speak. He can tell his side. Then this is wrong. Why? Because it is saying he don't have the right to speak. So this is wrong. He has the right to speak. Then third statement says that he or she shall not be entitled to vote on the first instance. So if you see here, when the speaker is presiding the house, then what will happen? Then he will be not voting in the first instance. You may all know that. But when this particular resolution, his particular removal resolution is in the progress, then he will be sitting as a normal member. He will be not presiding the house as a speaker. He will be literally sitting as a normal member. So as a normal member, he has the right to vote in the first instance. Okay, so this statement is also wrong, because this statement is saying he does not have the right to vote in the first instance. No, he has the right to vote in the first instance because he is a member of the Lok Sabha. Okay, then this is also wrong. So what would be the correct answer? Option A, only one is the correct answer. Next question. With reference to the Indian Parliament, consider the following statements. Statement 1, a bill pending in the Lok Sabha lapses on its dissolution. Statement 2, a bill passed by the Lok Sabha and pending in Rajya Sabha, it lapses on the dissolution of Lok Sabha. Statement 3. A bill in regard which the President of India notified his intention to summon the houses to joint sitting, it lapses on the dissolution of Lok Sabha. So if you see here, they are talking about, the lapse of bill during the dissolution of a Lok Sabha. We all know that this Lok Sabha is not a permanent body. It goes through dissolution every 5 years. But in some cases, it goes through dissolution even before the completion of the 5 years. We call it as premature dissolution. Okay, so when this Lok Sabha is going through some sort of dissolution, both in cases like after the expiry of 5 years, or let us say it is going through a premature dissolution before the completion of 5 years. In both the cases, when the Lok Sabha is getting dissolved, then what will happen to the bill which is pending in, either house of the parliament? This is what the question is talking about. So the first statement says a bill pending in Lok Sabha lapses on its dissolution. So if you see, yes, if there is a bill which is actually pending in the Lok Sabha and the Lok Sabha got dissolved, now this bill will also get lapsed. Okay, so this statement is a correct statement. Then a bill passed by Lok Sabha and pending in Rajya Sabha lapses on the dissolution of Lok Sabha. So if you see here, there is a bill which is already passed by the Lok Sabha and it is pending in the Rajya Sabha. In that case also, during the dissolution of Lok Sabha, the bill will be lapsed. Okay, so this statement is also a correct statement. Then statement 3 says that a bill in regard which the President of India notified a joint sitting, it lapses on the dissolution of Lok Sabha. So what they are technically saying is, when the President calls for a joint sitting, okay, when will the President call for a joint sitting? When there is a disagreement between Lok Sabha and Rajya Sabha regarding a particular bill. Okay, so let us say this Lok Sabha which got dissolved. Okay, before this there was a disagreement between Lok Sabha and Rajya Sabha and the President called for a joint sitting. Then the bill which is for particular bill they have called for the joint sitting, this particular bill will not get lapsed. Why? Because anyway the new Lok Sabha will be coming and this Lok Sabha and the Rajya Sabha will be present in the joint sitting, and again they'll be trying to pass this particular bill. So anyway this new Lok Sabha is going to be taking part in the passage of this particular bill from the zero. So in case the president has notified for a joint sitting, okay, before the dissolution of a Lok Sabha, when what happened, this Lok Sabha got dissolved, then also this particular bill will not get lapsed. Okay, the new Lok Sabha will be coming and they both, Lok Sabha and Rajya Sabha, they'll sit together and they'll be trying to pass this particular bill. So we can say this particular statement is a wrong statement. So option B, 1 and 2 is the correct answer. So when does a bill lapse? There are some conditions, okay, during the dissolution of Lok Sabha, the bills will get lapsed automatically. Okay, what are these conditions? What are these cases? First case is when the bill originates in Lok Sabha and remains pending in the Lok Sabha itself. Okay, let's say the bill get introduced in the Lok Sabha and it is still pending in Lok Sabha. It is not passed in Lok Sabha itself. It's still pending in Lok Sabha. In that case, obviously, yes, with the dissolution of Lok Sabha, the bill will get lapsed. Okay. The second case is, let's say the bill got introduced in the Lok Sabha and the bill was passed in the Lok Sabha. Then this particular bill is transmitted to the Rajya Sabha. And after that, the bill is pending in the Rajya Sabha, the Lok Sabha got dissolved. In that case also, the bill will be lapsed automatically. So if you see in both the cases, the first case and the second case, it is actually similar, irrespective of whether the bill is pending in Lok Sabha or pending in Rajya Sabha, but the bill is originated from the Lok Sabha, it is going to get lapsed with the dissolution of Lok Sabha. I'll repeat it again. In both the cases, the first case and the second case. First case is what? First case is the bill got originated from the Lok Sabha, but it is pending in the Lok Sabha itself. Okay? The second case is the bill got originated in Lok Sabha, but it got passed in Lok Sabha and it is transmitted to the Rajya Sabha. Now this particular bill is pending in the Rajya Sabha. Okay? In both the cases, the bill was originated from the Lok Sabha. Okay, so the bill, when it is originated from the Lok Sabha and it is pending in either Lok Sabha or Rajya Sabha, in both the cases, the bill will automatically lapse when there is a dissolution of Lok Sabha. Okay, understand, right? Then a bill that originates, yes, this is what I said you. These 2 points we covered. Then third case would be, let's say the bill originate and passed in Lok Sabha. Okay. So this case I told you. Then what is the third case? It would be when a bill originates and is passed by the Rajya Sabha, but is pending in the Lok Sabha. It also lapses with the dissolution of lower house. So the third case would be, let us say this particular bill has originated from the Rajya Sabha. Okay. But it is pending in the Lok Sabha. Then also this particular bill will be lapsed. Okay. Then the fourth case would be, the bill originates and is passed in Rajya Sabha, but is returned with amendments to the upper house by the Lok Sabha. Then does not get clearance of the Rajya Sabha, is considered to be have lapsed on the date of dissolution of lower house. So let's say a bill, it was introduced in the Rajya Sabha and it was passed in the Rajya Sabha and it was transmitted to the Lok Sabha. Now the Lok Sabha sent this bill, for reconsideration to the Rajya Sabha. Then also this particular bill will lapse automatically on the dissolution of Lok Sabha. So what are the cases we saw? We saw 4 cases here. So let us recall these 4 cases. In the first 2 cases, the bill was originated from the Lok Sabha, and in the first case, the bill was pending in the Lok Sabha. In the second case, the bill was pending in the Rajya Sabha, and in both these cases, the bill will lapse automatically on the dissolution of Lok Sabha. And what is the third case? The third case is, let's say the bill was originated from the Rajya Sabha and it was transmitted after getting passage, it was transmitted to the Lok Sabha, and now the bill is pending in the Lok Sabha. Again, this particular bill will be automatically lapsed. And we have the fourth case, that is when there is a bill which got originated from the Rajya Sabha and it is transmitted to the Lok Sabha, and the Lok Sabha sent it for reconsideration to the Rajya Sabha again. Again, this will also get lapsed automatically once the Lok Sabha get dissolved. And these are some conditions or cases where the bill does not lapse during the dissolution of Lok Sabha. So what are these cases? So the first case is, let's say a bill is originated from the Rajya Sabha, but it is pending in Rajya Sabha itself. It has never reached the Lok Sabha. It is still pending in the Rajya Sabha. In that case, this particular bill will not get lapsed. Okay. Then, so the second case would be the bills that got clearance from both the houses. Let's say, irrespective of the origin of the house, even though it's originated from the Lok Sabha or even though it's originated from the Rajya Sabha, but ultimately before the dissolution of Lok Sabha, this bill got passed by both the houses and it is presented to the president for his assent. Okay, in this case also the bill will not get lapsed. Okay, this is one of the important point which you have to remember, that is when the bill get clearance from both the houses and it is presented to the president for his assent, then also this bill will not be considered to be lapsed in the case of dissolution of a Lok Sabha. Okay, then the other case would be before the dissolution of Lok Sabha, the president he called for the joint sitting. When there is a disagreement between both the houses of parliament and the president called for a joint sitting, and after this the Lok Sabha got dissolved, then this particular bill will not get lapsed. Why? Because the new parliament will be coming and both Lok Sabha and the Rajya Sabha will be sitting together and try to pass this particular bill. So when the president has notified a joint sitting and then after that the Lok Sabha got dissolved, then also the bill will not be considered as lapsed. Okay, so this particular point and this particular point are different point. This is the first case, this is second case, and this is the third case. And what would be the fourth case? Let's say a bill has been passed in both the houses. Okay, and when it is presented to the president for his assent, he send it for reconsideration. This is also a case. So whenever the president send a bill for reconsideration, then also this particular bill will not be considered as lapsed. Okay, it will not lapse because the new Lok Sabha again it will be trying to pass this particular bill. The new Lok Sabha which got elected, they'll be trying to pass this particular bill. Okay, so whenever the president he sends a particular bill for reconsideration, then also this bill will not get lapsed after the dissolution of Lok Sabha. And the other cases, that is the fifth cases, those bills pending, okay, or those pending assurance and pending bills which are pending for the examination of Committee on Government Assurance. So some bills or some assurance, they'll be examined by this particular committee, this particular parliamentary committee, Committee on Government Assurance. So when there is a bill which is pending for the examination of this particular committee, then this bill will not be considered to be lapsed during the dissolution of Lok Sabha. So these are the five cases where even though there is a dissolution of Lok Sabha, the bill will not be considered to be have lapsed. Okay, then next question, with reference to the Parliament of India, consider the following statements. Statement 1, prorogation of a house by the President of India does not require the advice of a Council of Ministers. Statement 2, prorogation of the house is generally done by the House in adjournment sine die, but there is no bar to the President of India prorogating the house which is in session. Statement 3, dissolution of Lok Sabha is done by the President of India who, save in exceptional cases, circumstances, does so on the advice of the Council of Ministers. So if you see, the first statement says the prorogation of a house by the President of India, it does not require the advice of the Council of Ministers. So if you see, in most of the cases, the President should act, by the advice or the recommendations given by the Council of Ministers. He does not have many discretionary powers. He only have very few discretionary powers, and we usually read these discretionary powers. Okay, we usually read about these discretionary powers. So this one is not a discretionary power. We might have not read it anywhere. So this particular thing should be done by the President in accordance with the advice given by the Council of Ministers. He cannot act in his discretion in this particular case, okay, during the prorogation of a house, he should act according to the advice given by the Council of Ministers and not by the his discretion. So what they are saying is prorogation of a house by the President of India does not require advice of the Council of Ministers. No, it's wrong. Okay, because it's not his discretionary power. Then statement 2 says that prorogation of a house is generally done after the house is adjourned sine die. Is that true? First half of the statement, let us see. First half. So what they are saying in the first half is the prorogation of a house is usually done after the house is adjourned sine die. Is that true? Yes. Usually the prorogation is done by the president after the adjournment sine die. What is adjournment sine die? Adjournment sine die is to terminate the sitting of the parliament. Okay, to terminate the sitting of a house, both the houses. Okay, so this is adjournment sine die for indefinite period. So without mentioning when the next sitting is going to happen, without mentioning those that time period, for indefinite time of period they are proroguing, sorry, not proroguing, they are doing the adjournment, that is adjournment sine die. Okay, to terminate the sitting of the houses. This is done by the president and it is usually done after the so once the adjournment sine die happens, then the prorogation usually it will happen. Okay, but the second half of the statement says that but there is no bar to the President of India prorogating the house which is in session. Yes, this is true. The President of India can prorogue a particular session even though this particular house is in the session. Okay, so the President of India can prorogue the houses when the house is in the session. One case. Second case is when after the adjournment sine die he can also prorogue the house. So these two are correct. So this statement is a correct statement. Statement 3, dissolution of Lok Sabha is done by the President of India, who save in exceptional circumstances does so on the advice of Council of Ministers. Yes, there is a provision for dissolution of Lok Sabha. When the Council of Ministers, they are advising the President to dissolve the Lok Sabha, then he can actually dissolve the Lok Sabha. So this statement is also correct. So what would be the correct answer? Option C. 2 and 3 are correct answer. So if you see here, this is about the session of the Indian Parliament. Okay. So what is a session? Let's say in India, in case of India, we usually have 3 sessions of Parliament in a particular year. We have a budget session, we have a monsoon session, and we have winter session. Okay, usually we have these 3 sessions. So session is nothing but, let's say, for 2 to 3 months. Okay, approximately the house is going to be, they'll be having the meeting every day, almost every day, for around 2 to 3 months. So this is called as a session. Okay, for example, I'll give you an example. Let us say there is a student and let's say he's going to a college. Okay, so let us say 1 semester, it is similar to the session of the Parliament. Okay, I'm just giving an example to remember. Okay, then between these sessions we have the time period, right? That is called as recess. So this is similar to the holidays. Okay, let's say we have first semester, we have second semester, and the time period, the holiday between these 2 semesters is called as recess in case of a Parliament. So whenever there is 2 sessions and 2 sessions, between these 2 sessions they'll be having a holiday. This is called as recess, and during this recess the houses will be not in session. Okay, so if you see here, there are usually 3 sessions in a year. They are a budget session, approximately from February to May. Okay, 2 to 3 months. Then we have monsoon session, that is from July to September, and we have winter session, that is from November to December. Okay, and you might also know that the largest session would be the budget session. Okay, so this is session, and a session contains many meetings. So let us take one session, let us take the budget session, or let us take the monsoon session. So in one session they'll be having different meetings. Okay, one meeting is nothing but one day. In one day they'll be having one meeting, and in one meeting they'll be having two sittings. Okay, the timing, if you see, the first sitting will be from 11 a.m. to 1 p.m. and the second sitting will be from 2 p.m. to 6 p.m. Okay, wow. So these two sitting in one meeting, they'll be having two sittings. So a collection of meeting during a period for 2 to 3 months, this is called as a session. Then a sitting of a parliament can be terminated by adjournment. So what is a sitting? We just now we saw in a day they'll be having one meeting, and this meeting is divided into two sittings. Sitting 1, that is from 11 a.m. to 1 p.m. and we have second sitting. It is post lunch. Okay, we have these two sitting in a day. So this adjournment is nothing but a termination of a sitting. Let us say they want to terminate this first sitting. The speaker will be adjourning this particular house. So adjournment is nothing but the termination of a particular sitting. Okay, then what is adjournment sine die? So only one difference is there between adjournment and adjournment sine die. Both of them refer to the termination of a sitting only. But the only difference is, in case of the adjournment, they'll be mentioning when the next sitting will be there. They'll be mentioning the time. Okay, when the next meeting will be there. But in case of an adjournment sine die, there will be no mention of when will be the next sitting will be there. Okay, only this difference is there between adjournment and adjournment sine die. Then we have prorogation. What is prorogation? Prorogation is termination of this particular session. Okay, then, and we'll be seeing some of the terms which are related to the sessions of the parliament. First is summoning. Summoning is nothing but calling all the members of the parliament by the president. So the president of India will be summoning all the members of the parliament to the place or time which he thinks is fit. Okay, this is summoning. And in the constitution they have mentioned that the maximum gap between two sessions, it should not be more than 6 months. Okay, at least within 6 months they will be conducting another session. Okay, they have not mentioned there should be 3 sessions in a year or the time period for any particular session. This is not directly mentioned in the Constitution of India. But what is mentioned in the Constitution is, between any two sessions, the maximum time period should be less than 6 months. Okay, not more than 6 months. This is what is mentioned in the Constitution of India. So which means the the parliament should actually meet twice a year, at least twice a year. Okay, at least the Parliament of India should have 2 sessions. Minimum it should have 2 sessions. This is what is given by the Constitution of India. So that is summoning. Summoning means calling all the members of the parliament by the president. That is summoning. Okay, then we have adjournment. So what is adjournment? Adjournment is, it suspends all the work in a sitting. And in case of adjournment, they always specify the term for the reassembly. When will be the next sitting or the next meeting will be happening? They'll always specify this particular time. Okay. And this adjournment can only terminate the sitting. As we already saw in a meeting, in one day, we have 2 sitting. First sitting and we have second sitting. So this adjournment can only terminate the sitting, not the session. Okay, let's say the budget session is happening or the monsoon session is happening, the adjournment can only terminate this particular sitting and not the session. Okay, then the power of adjournment lies with whom? The speaker or the chairman. So the presiding officer of that particular house, in case of Lok Sabha, the speaker has the power to adjournment, and in case of Rajya Sabha, chairman also have the power for the adjournment. So technically the presiding officer has the power for the adjournment. Okay, and the adjournment terminates the sitting and not the session. Then we have adjournment sine die. So this is also a termination of sitting. Just in case of adjournment, this is also similar to adjournment. The only difference is it is done for an indefinite time period. It does not mention when the next sitting is going to happen. Okay, so this is also termination of a sitting, adjournment sine die, but it does not mention when the next sitting is going to happen. And the power of adjournment sine die is also lies with the presiding officer of the house. Let's say in case of Lok Sabha, the speaker has the power to, adjournment sine die. And in case of Rajya Sabha, the chairman has the power for the adjournment sine die. So both in case of adjournment and in case of adjournment sine die, both these power lies with the speaker or the chairman, that is the presiding officer of that particular house. And both these terms are directly terminating only the sitting and not the session. Okay, then we have another term, that is prorogation. What is prorogation? Prorogation means termination of a session. We were talking about adjournment sine die, both are termination of the sitting and not termination of the session. But prorogation is nothing but it is the termination of a session itself. Let's say monsoon session, the session itself is terminated by the prorogation. Just like the President of India, he has the power to summon the houses to start a session. Okay, just like that, the President of India has the power to prorogue a session. So what does this prorogue means? Which means to terminate a session itself. And this power also lies with the President of India. So the prorogation terminates both the sitting and the session of a house, and usually within a few days after the house is adjourned sine die by the presiding officer, the president issues a notification for the prorogation of a session. So the thing is, as I already told you, to terminate a sitting, the presiding officer will be issuing an adjournment or adjournment sine die. So in case of adjournment, they'll be mentioning when the next sitting is going to happen. Okay, let's say the last sitting is happening and the presiding officer will do the adjournment sine die because he don't know when the next sitting will be happening. So in that case, the presiding officer will be issuing a adjournment sine die. After some days of adjournment sine die, the president will be issuing a prorogation. What is prorogation? Prorogation is termination of the session of both the houses of parliament. And who has the power for prorogation? The President of India has the power for prorogation. But in some cases, the President also has the power to prorogue a house, which is even in a session. Okay, not just after the sine die, even before the sine die. When the house is already in session, then also the president can prorogue a particular house. Okay, so these two are the things. Then we have dissolution, and as already we saw, the Lok Sabha goes through a automatic dissolution after every 5 years, and it can also go through the dissolution process we call before the completion of the 5-year period. We call it as premature dissolution. When the Lok Sabha, in the Lok Sabha, the Council of Ministers, they are not able to show, the confidence, and let's say they lost the majority. In any case, the Lok Sabha will be dissolved. There are cases the Lok Sabha will be dissolved in less than or before the completion of the 5 years. Okay, that is dissolution. So what this dissolution does is it ends the very life of the existing house. That is the Lok Sabha itself, the house itself getting dissolved. Okay, the life of the Lok Sabha is itself, gone. But in case of Rajya Sabha, we know that it is a permanent house. So it does not go through any dissolution. But in case of Rajya Sabha, the house itself will get dissolved. Then a new house is being constituted after the election. Okay, then election will be happened. Then a new house, a new Lok Sabha will be getting elected. Okay. Then in case of Rajya Sabha, it is a permanent house and it is not subject to dissolution. Only Lok Sabha is subject to dissolution. And in case of dissolution of Lok Sabha, we have two type of dissolution. One is automatic dissolution, which happens every 5 years. Because the term period for the Lok Sabha itself is 5 years. After 5 years, it automatically loses its life. It automatically dissolves and a new election happens and a new Lok Sabha will be selected. But this is automatic dissolution. And there is another case where the dissolution happens by the order given by the President of India. Okay. In this case, there are chances that the dissolution will be happening before the 5 years period. It is a premature dissolution. So let's say in one case, the Council of Ministers, they could not show the confidence of the Lok Sabha. Then what will happen? Then they have to resign. Okay, then there is no other party which can show the majority in the parliament. Then the president will be dissolving the Lok Sabha. And there is another case. What is that? So when the Council of Ministers, they are advising the president to dissolve the Lok Sabha, then the president has the power to dissolve the Lok Sabha only after the recommendation of the Council of Ministers. So that is also there. So in any case, with the order of the president, he has the power to dissolve the Lok Sabha even before the completion of the 5 years term. Okay, so these are some of the terms which were related to the parliament or the sessions of the houses. Okay, so with that we have completed this particular topic, union and state legislature. We have completed this topic. We'll be starting with the next topic. I think it's judiciary and its related terms, related facts. Okay, so we'll be doing that topic next and we'll be completing the PYQs related to that particular topic. Okay, so with that we'll be seeing in the next class. Thank you, students. So as I already told you in the starting of this video, please do comment and tell me whether what you are doing exactly, like which attempt you are about to give and whether you gave this attempt or not. Are you complete fresher? So just tell me that, and so that I'll be able to explain in that particular perspective. Okay, so that's it. Thank you, students.